we're doing. Let's see. So now it's supposedly recording. Give it a second, and then I will stop that, and then see where you should be. Something should tell you this meeting is being recorded every time you join.
Oh yeah, on the top left, yeah.
Yeah, in the top right you see it's red. So just testing that meeting. I'm not sure how GoToMeeting handles recording. Maybe it's after when everything is done, it goes and processes and then send you a link. So
because أنا جربتها مع شكون خي قاعد درت التست نناقش و it went well, yeah.
Yeah. Let's see.
اللي قديمه اللي يجوني ان شاء الله هو تتسجل.
Yeah, let me stop that one, sorry. Testing, recording, started recording. Okay, so first of all, I'd like to thank everyone who managed to join us today. I know it's Saturday, everyone is busy, and we can tell from Umaima's, she's on a train. She's definitely busy. Thank you so much, Dr. Jeffrey, for taking your time and to join us and clear out a number of questions that many people seem to have, and simplify the complexity of the international law in general. We hope to ask you a couple of questions that we've gathered that we think the majority of people are interested to know of. And to start, since this meeting will be recorded, I would like to introduce Dr. Jeffrey Smith. He is a professor of international law in Ottawa, Canada, and he is also a participating lawyer. He worked as a counsel to the United Nations administration in East Timor during the East Timor transition to independence. He has written extensively about Western Sahara. His latest publication concerns with the crime of aggression in the territory of Western Sahara. His research interests include a variety of areas, including the human rights protection in the occupied and colonized countries, the law of the sea, the environmental regulations in polar regions, and international criminal law. Dr. Jeffrey, I'd like to start by, again, thanking you for joining us and ask you a number of questions, start questions, and by a few questions, and I'll give you the platform to go ahead and just start by generally giving us the legal status of Western Sahara.
All right, thank you. And thank you, Moulay, for that introduction, and Jamal for your work in bringing us together this afternoon. I was listening to some of the dialogue in Hassaniya, and it seemed to be such a wonderful symphony of voices to be sharing or to be taking in, as if I were back in the camps among friends. And after not traveling for almost 4 months, it's a delight. Maybe I'll hear a bit more. And by all means, although you will direct questions to me, I'm entirely happy to be interrupted along the way. And of course, for a more free-flowing exchange, Moulay and Jamal a bit later on, I think in the hour that we have. Your first question is, what is the status of Western Sahara? And my answer is somewhat cryptic, or what you would expect from a law professor. Which is, well, there's a different, which is, to put the question back to you, what do we mean by Western Sahara? The territory or the people? And of course, I mean to confound our thinking a bit. Well, we'll get to the rights of the Sahrawi people in a moment, but maybe we should think of the territory as land territory, because that's in easy place to start. And also perhaps, if unfortunately, the most settled part probably of international law as we understand it, international law in the modern sense. And of course, the ideas of territory, I don't mean to sound too theoretical, the ideas of territory and how they fit and the rules around them in law are very much Western ideals. I mean, I think a thing that I would say as a person who is a Western jurist, trained in a Western legal tradition here in Canada, is that international law very heavily adopts Western notion or global North ideas, including about territoriality. Of course, those are good things when it comes to the Sahrawi people, because it gives both more certainty, but it also fits or aligns with the decolonization of your territory. And we'll have some questions where I'll explain that. But let me answer the question. The territorial status of Western Sahara is quite settled and very clear. It exists with borders or boundaries that were created in the colonial era. I'm happy to talk about that. I think it's quite fascinating and artificial how they were arrived at. And no one has suggested, other than the occupier, that those boundaries are incorrect or should change or are no longer lawful or bind or obligate others to respect them, including what we now understand to be Sahrawi rights into the Atlantic Ocean, into the ocean from that territory. The notion of territory as having rights and legal control is becoming clearer in the Atlantic Ocean, and I can talk about European fisheries and so on. But the status of the territory of Western Sahara, to answer the question, is clear, has been clear, and is getting in a way more clear because of the advance of the law in recent years. And that seems to be an odd thing to say. I'll point to the Mauritius case last year in the International Court of Justice about the Chagos Islands that were split away from Mauritius just before independence. The International Court of Justice said the idea of territory and decolonization was settled as far back as 1965 or 1968, such that this part of Mauritius to become independent should not have been split away. That's an odd way to approach the law, as if now when we reason the law, we understand it to have been more clear, more settled, even earlier in the age of decolonization than we had thought or was argued. So that's the territory. Western Sahara exists with boundaries. It is understood almost universally to, one, its people to enjoy the right to decolonization, and two, that territory with a competent government and the people present in it is recognized to have legal personality or status as a state by a number of other countries, particularly in Africa. So that's, thank you for the easy question to start.
Thank you. The second question will be why Western, this is in respect to the United Nations Security Council, why is Western Sahara in Chapter 6 and not Chapter 7 at the level of UN Security General and the United Nations Fourth Committee or the Decolonization Committee?
Well, the second part of that question is easier to answer, and I think it is a fortunate thing. Why is the case of Western Sahara, or the question, as the United Nations has called it, since the 1960s and certainly since 1975, why is the question still before the General Assembly? Well, because the United Nations organization and the community of states understands Western Sahara to be a case of decolonization or arriving at self-determination from the era of European colonization, that it is unfinished business. So I say that it is good that there is one place in the United Nations, the General Assembly's committee, where there is a revisiting and a consideration year over year. Of course, that also allows the United Nations, or the community of states that is the United Nations, to simply leave the problem or the question there without more. After the 1970s and 1980s, as the great cases of self-determination, Timor-Leste and Namibia, Southwest Africa, Namibia, became dealt with, the issue or the problem of decolonization moved into the Security Council. The Security Council had operational direction of getting through decolonization, significantly because of referendum missions, as we saw in Timor-Leste 20 years ago or 21 years ago, kind of right at this time of year, right? And so it became in the late 1980s and by 1991 that the Security Council would be leading and therefore taking charge or directing what was to be done. And it was understood, of course, in the settlement plan, and we all know this, this is not something I need to touch on very much, that that would be a referendum for self-determination. That's the agreement. That's been the direction. And so that approach answers the first part of the question, which is, why is it Chapter 6 of the UN Charter? Why does the Security Council pursue peaceful means? Well, because that's what's to be agreed upon. Of course, the question today is, given the impasse or the nature of the occupation and annexation, why isn't Chapter 7 being considered? And the answer to that is that it's too politically difficult for the Security Council, that the whole question, including the application of the law, as much as that is important or matters, has stalled in the Security Council. The Security Council is ineffective or unable to get a consensus, even on moving Chapter 6 referendum or other persuasive measures, quite apart from coercion or indeed, as Chapter 7 allows, the use of force.
Thank you. And just staying in the same topic as far as the United Nations Security Council, we have a very common question, which is the difference between the international law, the humanitarian law, and the human rights law, or international law and human rights. And a common question comes in, which of these can be applied to the case of Western Sahara?
As our meeting goes on, my answers can get a bit easier. Both. There are broad sources or categories of law which clearly do apply, but we lack the means or the consensus or the capacity to do so. And before I get into what those sources of law are and try to help us make sense of them, let me observe that various people in various places in recent years have tried to bring the law to bear on many aspects of the status of Western Sahara and the rights of the Sahrawi people. I can give you an example from this week, and it's just kind of emerging, but it's from this week, so it helps to illustrate the point, how people are working. And then I'll offer another short example. The example from this week, which is worth following up, was on the periodic review of how Spain meets human rights obligations under international human rights treaties, human rights law that governments and countries are to adopt and ensure are applied to their people and peoples within their country, or people for whom they are responsible. And so in Geneva, it has emerged that Spain has been called out on its lack of protecting natural resources in Western Sahara during a periodic or 4-year review cycle by the UN Human Rights Council of Spain's human rights progress under certain international human rights treaties. Okay, and the interesting point is that 2 countries, Namibia and Timor-Leste, had made those observations, saying, UN Human Rights Council, we remind you that the country with colonial responsibilities, Spain, has not done what it should do to protect the resources which are owned by the Sahrawi people. And that's a remarkable thing, to think that there are other countries who have been in the same situation as Western Sahara, the Sahrawi people, are using a human rights treaty mechanism or process to illuminate Sahrawi human rights. It seems very small to us and as if it doesn't have an effect, but it's huge. The other thing I can point to about a recent use of the law, of course, is the Sahrawi republics cases in 2017. They were three years ago, to use civil commercial law to intercept cargoes of phosphate rock exported from the occupied part of your country, from the occupied part of Western Sahara. And that's a fascinating use of these various streams or points of law to assert Sahrawi rights, all of which, it seems to me, are directed into self-determination, into ending the occupation. So but let me, one more thing to answer your question. There are human rights obligations and rules and law under the great treaties of our era that emerged after the Second World War. They very clearly apply to Sahrawi people. They very clearly apply in Western Sahara. And then as a category within that, or as a narrow area, there is what we call international humanitarian law, which is the law of how warfare is conducted, or the law of occupation as well, even if there is not an active conflict or active hostilities, as is the case throughout Western Sahara. And a part of, or a branch of that law, IHL, is directed to protecting civilian people, and yes, their resources as well, during times of conflict. There's absolutely no question that law applies to directly protect Sahrawi people, but it is not being applied. Spain is absent, the occupier is not much interested in applying it, and no other country from the international community will come in and seek to apply it. And the other problem of the law of occupation within, again, IHL, is that if we begin to think about it and talk about it among other countries, we realize that we too, as other countries, are prevented or limited from engaging with an occupying Morocco, because though that area of law has firmer or more obvious obligations on how we act. So the international community tends to shrug off or to not pay attention to that law. It is, and let me illustrate this with an example, again, from resources. It is wrong in international law for my country to have imported phosphate rock from the occupied territory. And the case in South Africa helped to illuminate that or to explain it. But it is very much more wrong. It's a very clear line if we consider that that phosphate rock was criminally taken, was taken as an act, as a war crime from occupied Western Sahara. And governments like mine in Canada don't need that diplomatic inconvenience. We have to deal with the occupier. And when we begin to apply or think about the law, it also limits what we can do to engage. And so the international community has been reluctant, and scholars like me haven't done a good job of explaining how international humanitarian law, the law of conflict, which has a criminal part or dimension to it, applies.
Thank you. And I wanted to just say this one more time for those who just joined us. If you have any questions, please type those questions on the chat, and we will make sure that we don't repeat the question. Thank you. The next question was, I should have asked this earlier, but it was around the same, the humanitarian law and the international law. And the question was, what are the advantage and disadvantage of each of these laws vis-a-vis the case of Western Sahara? And not why none of these laws, there has been some cases that you mentioned where these laws have been used or applied, but why none of these laws have been, not all of them, I guess, have been applied to Western Sahara? Why, if there is a clear cut of this law, what prevents it of being applied in various cases, including, for example, this taking, for example, those fisheries cargoes from Western Sahara and allowing that to be transported to a different country, given that there is a clear law that this is being exploited from a territory without the consent of the people?
Well, that's a great question, and that's much of what has been going on in recent years, both by the Sahrawi government and certainly by Sahrawi civil society, by individuals and organizations, and I would say clearly by solidarity groups, most especially in Europe, Western Sahara Resource Watch, and the people in the United Kingdom. Why is that obvious or settled law not more applied? There's a number of answers, none of which are satisfactory, none of which any of us should be happy with. It is complex and costs money to get into court when, if we are pursuing justice, governments that should be are not. And you can see this obviously in a place like Canada, but more in Europe in recent years with the cases, the Frente Polisario, the Polisario Front has brought in the European Court of Justice in an effort to limit how the European Union, the European Commission and Council deals with Morocco in Western Sahara. You can see that in those cases, but those cases are complex, they cost money, they take time to organize, but they are very much worth pursuing, as we can see from the Sahrawi government's cases in Panama and South Africa in 2017, and what the people in the United Kingdom did, Western Sahara Campaign, United Kingdom did in the United Kingdom in a case that went over to the European Court and then came back. Essentially last year it came back. There was a tremendously good result in that. The other part of this is, although the law is settled, there is very little cases. There's very few judgments that in this area of occupation, of natural resources, of self-determination. The great decolonization cases of recent years that were in parallel with the Sahrawi peoples, Namibia and Timor-Leste, never had access or used or applied the law, never pursued things through courts or argued the application of the law to governments and civil societies. So Sahrawi people and their supporters have been pioneers in this regard. And so, you know, within the last decade, we have seen more arguing and a better understanding of what the law is, and some application or use of it. And that toward the project of self-determination, yes, it's about resources. It's absolutely about individual human rights and protecting people. But toward a project of self-determination, it's frustrating, of course, but you do see results. You did see a change of behavior very quickly around the phosphate trade after the 2017 cases. I mean, I can elaborate on that, and some others have made comments. So we must keep trying. And a part of it is, of all of this, is also what the law is in its complexities, is that there are only so many places to compel individuals and governments to act. There are only so many countries, so many legal traditions. We would not be bringing a case in the courts of Algeria because exporting that case seems impossible or improbable. Should we be bringing cases in the courts of Spain? Yes, and some cases have been, including on the criminal side. Can we bring cases in a country like Canada? No. My country doesn't have that legal tradition or connection, so we come up short here. But all kinds of good people in Sahrawi civil society, and I know in government, are looking for answers where we can. But the law is only one tool or one instrument. There are other things of political and awareness and creating understanding that are a part of this as well.
Thank you. Before moving on to a somewhat a different topic, I'd like to ask one of the questions or two of the questions that the attendees asked. And Moima asked why the international community has failed the Pacific resistance of the Sahrawi people against the occupation. And the second question was, the second question was, the United Nations General Assembly has referred twice to the Moroccan presence as an occupation in 3437 and 3519, but once the United Nations Security Council took over, the UN resolutions became very unclear regarding many aspects dealing with Western Sahara issue. Is it possible to ask the issue to be dealt within the UN's UNGA rather than the UN's Security Council? And that was Sid Ahmed Julie.
Yeah. Oh, those are such good questions. We could have whole classroom lectures on each of them, and they're very important, and it's where the campaign or the fight needs to continue on, for better or for worse. The problem or the question of Western Sahara is understood among countries in the General Assembly. And when I speak to people in the Secretariat, not much Geneva, but more New York, there's a great deal of sympathy and understanding, even as that can't always publicly come out. So on the first question, why does the international community fail? The legal obligation to decolonize is a legal obligation on all of us as countries and I believe as individuals. and it's at the highest of requirements in the international system. It's a legal requirement. I can't be indifferent or passive to a non-self-governing people's status, and that's true of our governments. But why do we fail in that? Because the international community fails in these things and did so in other places. It failed to do so with Namibia until the apartheid regime was ended and itself would let go of Namibia. It failed horribly after 1975 in Timor-Leste until there was a change of regime in Jakarta in 1998. Palestine is a further example, or situations that are not decolonization but demand some intervention, such as Yemen, as some people argue. Why does the international community fail in these things? Because international law is weak. It's not compulsory. It's not binding. It can't be imposed on countries to end colonization, is the simple answer. And that is less a question of law and more a question of the international system. When the moment is right, Namibia and Timor-Leste tell us, the international community will coalesce. And in some respects, the work of what we do with the law very narrowly as one of a number of instruments is to provide that future foundation or that basis. It is both a wall to prevent further erosion of the right to self-determination, but is to make sure there's a ready foundation or a basis, a platform for the international community when the political moment is right to act. So that's the first question. Maybe there's a follow-up. The whole question, just turning to the General Assembly and the role of the UN General Assembly, is a fascinating thing. And in many respects, the General Assembly's treatment of Western Sahara from 1975 was the same in its treatment of Timor-Leste, with the important difference that the colonizing power years, and that important issue that was really helpful. But both territories, Timor-Leste and Western Sahara, have been called occupied. But the word occupied is a very inconvenient word. It has immense political and legal significance. And in a recent paper I've written about how the crime of aggression applies, and we can circulate that paper. It's in English and it's a long paper. I am again making the point that properly understanding the law and identifying it means yes, Western Sahara is a territory that is non-self-governing, that awaits decolonization, but at the same time, it is also a territory that is occupied, and that brings criminal law implications, or brings a dimension of the criminal law to both the status of the occupation and also to countries and governments. The word occupation is very inconvenient, and if you want an example of that, think back to 2016 when the UN General Secretary visited the camps and the liberated zone in Western Sahara, which itself is kind of a remarkable thing in UN diplomacy. It doesn't seem like much. And he said, and he would have known he was saying deliberately, that it was unfortunate that Western Sahara was still occupied. He knew exactly what he was saying because the word is charged. It has significance. And so this is why the General Assembly, annually dealing with Western Sahara, will shy away from that. During the 1980s and 1990s, especially going into the 1991 settlement plan, would stay away from that. We want a diplomatic equilibrium. We want a balance because we're trying to get the parties together. Well, here we are, right? And maybe it's time to be thinking about what occupation means. The other part of this question is fascinating, and a great man of decolonization, you know, a kind of hero of things, Pedro Pinto Leite from Portugal. He's just a lovely man, has written about this in the case of Western Sahara, that the UN General Assembly could take more control or power, could give more of a directing influence than the Security Council has done. And that is true, but it would have to be arranged. It is possible to do it, I like these ideas, in the way that the country of Mauritius got a consensus from other countries to address the problem of the Chagos Islands, the splitting off of the Chagos Islands in the 1960s, to take that and agree in the General Assembly with sufficient support to send it over to the International Court of Justice for a look. So you can get an agreement to move things and overcome the problems of the Security Council. And Pedro has done some great work writing about that. And those are projects that are important on the diplomatic side.
Thank you. The next question will be, this is maybe a little bit of different topic, but it will be in regards to the administration of the Western Sahara territory. So Western Sahara and the issue of administration and representation. Who is the administrative power, and who has the right to grant administration at the international level? What responsibility of Spain toward Western Sahara and the people of Western Sahara? And then we'll go next to the terminology where there is a lot of confusion takes place. Thank you.
We could write libraries on this subject, and there are some scholars who address it better than I do. Who's the administering power? I think we can accept that Morocco is administering in the sense of the application of the law of occupation. And for the most part, we must remember its obligations committed to under the 1991 settlement plan. And, you know, elements of the settlement, the settlement plan we understand from what the UN Security Council was prescribing for it, right, at the time. None of that has gone away. It might seem impossible, it might have stalled, but the settlement plan is a settlement plan, and it's founded or based in international law. The Sahrawi people have the right to self-determination. The United Nations will organize a referendum in the territory. And so short of that, it is understood under the settlement plan that Morocco would have administration. Of course, I've left a part of the territory out, haven't I, which is the liberated zone. And you know, I don't mean to be humorous about it, but there are two parts of Western Sahara that are under differing administrations. Other than Morocco, I've never heard it said that the Sahrawi entity or state should not be or is not the administering power inland or east of the berm. So that, I mean, that's an important thing to know, right? So I think for purposes, again, of international humanitarian law, the law of occupation, Morocco is administering, and I think it has administration obligations, including the maintenance of human rights, in the part of the territory it controls because of the 1991 settlement plan. But that's the end of the matter. And it is also overlaid with, or on a parallel track, you have Spain's continuing obligations, its duty to ensure or arrive at, to deliver self-determination to the Sahrawi people. So nothing could ever displace that. So maybe I'm a lawyer and I'm the only person who can think, oh, there can be two administering powers in the occupied area of Western Sahara, but there are, and you can see that in the criminal cases. I know of two of them. Two of them in Spain, where Spanish criminal courts have concluded, the Audiencia Nacional, which is an appeal court, has concluded, oh yes, Spain's criminal law applies where Spain is responsible. And that's in Western Sahara. There's an interesting question of whether it applies in all of Western Sahara, and probably the answer is yes, even as the Sahrawi state is present in the liberated zone. But I mean, that's a bit of a theoretical question. So you can have two administering powers, so to speak. The greater or overall administrative responsibility is still Spain's. The next part of the question was, who has the right to grant administrative status? Well, I guess the International Court of Justice could declare on it, and I suppose the UN Security Council could decree which state, it can only be a state, is the administering power, except that the UN itself as an organization could come to administer Western Sahara, as it did in Timor-Leste, 1999 to 2002, in some transition to independence, which is an interesting thought, but we're not there yet. But having answered that part of the question, what we do know in international law, what the scholars are very much agreed on, is that Spain cannot give up. That Spain cannot say, oh, we're leaving the scene. This is not our responsibility. You having colonized the Sahrawi people in perpetuity, Spain has a responsibility to them. And if there are gaps or shortcomings in administration, then international law would direct Spain to cover them, to address them or deal with them. And of course, Spain will not, because Spain's in Europe and Spain has a relationship with Morocco and so on. And the result is that the Sahrawi people don't even have the administration, as it were, or the oversight of some responsible government, in particular toward the question of self-determination, that they should.
Thank you. And I have another question that is from the audience, and the question was from Haddamin, is the application of the Moroccan human rights laws. Does it confirm with the statute of the international law on the territory of Western Sahara? Can we apply those rules? Can we apply those human rights laws on Western Sahara, given that it's not fully recognized as part of Morocco? The second question that was in regards to the humanitarian, it says, do you think focusing on relief under the law has in some ways watered down other efforts for the independence of the territory? And another question in regards to Damezik, Yaram asked a follow-up on that. Why is the case of Damezik? Why did the case of Damezik didn't go through a review of in the Spanish courts? Those are some questions. Some of them are translation.
Thank you for the translation. More great questions that need follow-up. Let me try and deal with three of them in a way that is clear. Whether you accept Morocco to be an occupying power in the sense of a country invaded, for which international humanitarian law, the Geneva Conventions, the statute, which is a treaty of the International Criminal Court, is responsible or Morocco is administering under the settlement plan towards self-determination, just as a matter of decolonization, without any of the law of occupation applying, it still has obligations or duties toward the civil population to protect the civil population. And indeed, Morocco has joined the great human rights treaties of our time, the Civil and Political Rights Convention and the Economic and Social Cultural Rights Convention. And about 4 years ago, Morocco was commented on its performance of those treaties in the periodic or 4-year cycle review of human rights performance, as I was saying, had happened last week with Spain. And there was a commentary put into that brilliantly by the people in Brussels in Western Sahara Resource Watch around the issue of natural resources, which is worth considering that the UN Human Rights Council took up. So Morocco has an obligation to protect and provide for the civil population. And I think it is fairly clear, I argue this, I don't think there's much doubt, also to safeguard human rights, specifically in the area of a self-determination referendum. If Morocco agreed to the settlement plan, which was contemplating or planning, providing for a referendum that would include a choice or the option of independence, inherently or implicitly, Morocco must protect human rights to allow that to unfold or be realized. And that's rights of assembly, of coming together, and of expression, of political expression. I don't think there's much doubt about what those things are, that they exist, and that Morocco, and it seems acceptable for Morocco to require that, to accept that, and to require that of Morocco. And yet at the same time, moving to the second question here, which is just, it's a brilliant question. Does the notion of these things tend to entrench or perpetuate the occupation or the impasse, the not getting to self-determination? Yes, to a certain degree. The notion that things are made normal and there is an occupier which in some respects is providing things has tended to lead to things being stalled. The idea that the occupier has a complete responsibility and no other country or state does, or there's otherwise no accountability of Morocco and Western Sahara, yeah, it slows things down. It's a barrier, it's an impasse. It normalizes things, it makes things tolerable. Oh, well, the occupier is ensuring human rights. Oh, well, we have an acceptable human rights setting, except for the greatest human right of all, which is the people who have been colonized are to get a choice of politically what their society looks like, whatever that is, right? So we must be careful of these things. That there can be this unintended effect of thinking through or applying the law that tends to make things worse or slower. The third question is a good one, Gedem Isaac. Why is that case not pursued through the Spanish courts? There are two leading cases which continue in Spain. One is out of the single killing of a Sahrawi person at Gedem Isaac in November 2010. And there's a more historic case following the invasion and occupation, 1975 through sort of 1991, against 12 or 13 Moroccans. Those cases are very much alive, and they are under Spanish criminal law jurisdiction. But the ability of Spain's courts to investigate the cases in the occupied territory is kind of impossible. That's a first problem. And the second problem is that catching up to the perpetrators is kind of impossible. They don't tend to travel into countries where there would be a criminal law jurisdiction or the ability to nab them in the way like Pinochet in the 1990s in the United Kingdom out of Chile, right? That sort of started all this, or allowed what was settled law to then be courageously exploited. So this is why I have most recently argued, I don't want to tell you about what my project is, because I think it's no more important than some of the other scholars, but let me make the point by saying, this is why I wrote about the crime of aggression. The crime of aggression, I argue, applies to the case of Western Sahara because Spain's courts have a criminal law jurisdiction in Western Sahara. They exist there because of Spain's colonial responsibility. The courts have set us in the earlier Gadem-Isaac case and the other case I described to you. And Spain has signed on to the crime of aggression in the International Criminal Court. This is what this analysis was all about. But of course, there's something practical in that scheme, in that the crime of aggression can only apply to those most senior officials of a country responsible for the aggression: invasion, occupation, annexation, and I also say deliberately denying the act, deliberately denying self-determination of a colonized people. That is, I say, the crime of aggression, and I'm looking forward to what other scholars have to say about it. But there's a point behind that project, which is, if I am right that the crime of aggression exists, then the head of the Moroccan state and the head of the Moroccan government, and maybe a few other senior officials, need to think carefully about where they are traveling. That's the big case to be brought in the courts of Spain, and it would be a political sensation. The moment you start going after heads of government and heads of state, everyone's in a bother. Everyone is all exercised by these things. But I'm just a lawyer. We just have to call out criminal conduct where we find criminal conduct.
Thank you. We don't have a lot of time left, but we have still a few questions, so I will try to maybe pick and choose. So the next question I have here is the terminology issue, which is Western Sahara conflict versus a disputed territory. We always hear this: where are you from? I'm from Western Sahara. What's Western Sahara? The answer is always a disputed territory, and then you go over in the conflict. But in the context of international law, what's the difference between the two? And the second or the third question will be in regards to the MINURSO involvement. Why is it different from other peacekeeper missions? And what are the obligations? You already answered the obligation of the Kingdom of Morocco toward the people of Western Sahara in occupied territory. Third question will be in relation to identity paperwork, civil right, licensing of association, the status of political prisoners. Are they prisoners or POWs? If you can, and I have one or two more questions after that.
Okay. Oh, gosh, those are great questions. Let me be very brief. Well, everything is shades of meaning, isn't it? When we seek to advance the Sahrawi cause, we try to use plain language and return to fundamentals that cannot be argued away. My earlier remarks about occupation, my analysis about the crime of aggression, right, are in effect a call to return to fundamentals that can't be dismissed. But those who would dismiss or seek to erase what is going on use different language. The next time you're in conversation with someone about the status of Western Sahara, ask them what they think about the last great word, the judicial conclusion by the International Court of Justice in 1975. That's where we're at. Ask them what they think about that. Most people haven't read the case, or they say I'm not a lawyer or whatever, but when you run into someone who is apologizing or making excuses for the occupation and annexation of Western Sahara, See what they have to say about that case, because it's a return to the fundamentals. It's a foundation. It can't, no one would run around and say the International Court of Justice was corrupt, or that it didn't consider a huge amount of documents and evidence that was put before it by several countries, right? So it's terminology. And so where we are seeking to balance the parties involved, well, we must have regard for Morocco's position. Then we begin to use language such as, it's in dispute. It's not in dispute. A court has concluded on it, and virtually the whole international community does not recognize Morocco's claim. And I don't know of a credible lawyer or a legal scholar who says Morocco in some way has a claim to it. It's always fun to read articles that sort of suggest otherwise, because they're in a parallel universe. So it falls to us to use appropriate labels, and this is where the law is on our side. The crime of aggression is occurring. Tell me why it is not. And it's up to some of us. It's up to many of us, if we are intellectually honest, to hold these things forward. You know, if I don't do these things in the case of Western Sahara, pretty soon somebody will be doing them in the case of my country, right? So to speak. Why is MINURSO different from a peacekeeping mission? That's a great question. Because it's supposed to be a referendum mission. It is designed. It was a classic Namibia, East Timor-Leste referendum mission. The original terms of reference from 1990-91 are, we need to deploy military units, yes, but there was a ceasefire. There was nothing to secure. Military units, yes, to monitor that ceasefire, to ensure the good cooperation of the parties. But remember, MINURSO had a large component around identifying Sahrawi people and engaging the machinery toward a referendum. So it's a referendum mission. And I kind of like that, because that's what the issue is. We don't have two sides in a dispute over territory. We have the commitment of the two sides and the international community, most of all through the UN organization to administer. We have a commitment to a referendum, to a process, if you will. Should that process now change? Why not? Namibia never had a referendum. Namibia got to a constituent elected assembly, and the elected assembly said, we represent the will of the Namibian people now without an apartheid South Africa present. We're moving to independence, and the UN and the international community adopted that. So you don't always need a referendum, but that's what MINURSO is. Nothing has changed in that mandate. Get ready for a referendum is what MINURSO, which is really essentially a military presence, right? The 200 observers ensuring a ceasefire. That presence is hugely important to keep the world's attention on this last case of decolonization in Africa. We don't want, MINURSO may be ineffective and the UN has failed the situation, failed the Sahrawi people, but we don't want MINURSO to leave, because MINURSO is the physical manifestation or example of what an obligation is and the commitment or agreement to self-determination. So let's be careful with that. The next question, just going through them a bit faster than I have. The Kingdom of Morocco, what are its obligations in the occupied territory, and in particular with the application of criminal law or law enforcement? Those obligations are substantial and deep. They come from human rights law itself. Nothing suggests that although Morocco does not have a claim to or a territorial right in Western Sahara, that human rights law from the international setting as applied in Morocco should not be applied in Western Sahara. basic protections of people in a criminal justice system flow into Western Sahara in that way. And then there is also with international humanitarian law, IHL, or the law of occupation, the requirement to apply criminal law, but an existing criminal legal system. You can't invade a country, occupy it, and apply your own criminal law scheme in that, which seems very odd. An occupying country must maintain the criminal law system for civilian peoples. Combatants or soldiers are a different thing, and maybe that's for another discussion. Must maintain the existing system, which is this wonderful problem that existing system that the courts in Spain remind us has always continued to be Spain's legal system. That doesn't mean Morocco sort of has to allow Spain to operate things, but the procedural protections of the criminal law and Spanish criminal law apply as a legal obligation. They apply in preference to or priority over an occupying Morocco's law. So the criminal law in Spain protects, or at least does not make criminal, assembly of people in public for political purposes, a manifestation or demonstration. The criminal law in Spain sort of protects that, but at least it doesn't make it a crime, unless you're in Catalonia. I'm sort of joking. We all have our problems, right? But obviously, Moroccan criminal law says something different and has applied something different. If there's a competition between the two, international law of occupation, the Fourth Geneva Convention, says a civil population can't have its legal system swept aside because that helps perpetuate or deepen an occupation. And all the scholars and the courts and the other settings in the modern era have confirmed that. So isn't that a wonderful thing? We can all say Spanish criminal law should be applying, and we should get a protest into the streets to say, with signs that say only Spanish criminal law applies to me in this setting, exercising my political rights, calling for self-determination or whatever else we would gather for. It's kind of funny, right? But it does point to both the non-legitimacy or the illegitimacy of Morocco as an occupying power, and also this inability, this incapacity for us to, and Sahrawi people, to have access to the law or have it applied. And of course there are problems around the criminal law system that is applied that we know about. Substantial, significant abuses, both in process, which are in pursuit of the occupation. People removed, people tried in military courts, the extent of punishment, conviction of people under duress, and torture and with a lack of evidence. Those problems are well understood. They're notorious, and they themselves are both part of an occupation and they're criminal themselves, right? It's an easy thing to answer. So yeah, was there another part of that question, Moulay?
Yeah, the last part of the question was in regard to the identity paperwork, civil rights, the licensing of association, the statute of political prisoners. Are they prisoners or are they POWs?
Mm-hmm. The last one is fairly easy. I think POWs, and the law has been slow to evolve in this era of after the Second World War, when these things were conceived or reconceived. In general, there are not, the law of protection around prisoners of war applies to people who are regular combatants, soldiers captured. The law, of course, as we know, is weak on that, in some respects, in terms of how they are ultimately dealt with or repatriated in circumstances such as Western Sahara. But because there are no longer effectively prisoners, soldiers held by either side, the question has become a bit theoretical. The law is much more demanding on Morocco and also Sahrawi authorities, should they come across a Moroccan civilian, say in the liberated zone. That sounds a bit theoretical. The law is much more demanding on the protection of civilians, that civilian persons, whether they are Moroccan settlers or Sahrawi citizens or individuals in the occupied territory, must be given a high degree of procedural protection under the law. One may still commit a crime, theft, murder, robbery, that is not a political crime. And Morocco must be even-handed and use and apply criminal law to international standards. It's really supposed to be permitting locally arranged courts to carry on. But the problem with local courts is that Spain left in 1975 and there weren't functioning courts or a functioning national administration that could see to this. Yes, Spanish criminal law applies. So there's a fairly high degree. And the law is also clear that political prisoners should not be political prisoners for merely the crimes of political engagement, calling for self-determination, or public activity. Those are forbidden areas as a matter of both international human rights. People need to be able to get together publicly and express their political views in a nonviolent basis, and certainly when it comes to the law of occupation. And also, I would argue, under this third area of the commitments to the settlement plan in 1991. We agreed the Sahrawi people were going to move to a referendum. How would they engage the questions around self-determination unless political viewpoints could be expressed and shared, including public rallies or speeches or all manner of kind of public engagement that now is made criminal? You can't reveal or show a Sahrawi flag in the occupied territory. Well, that's an act of political expression. And it may be that campaigners are campaigning for independence as a choice. Well, and they want to display that flag, and that has to be tolerated. And that's an implicit term of the settlement plan, that there would be these discussions and debates and displays and so on. So that's a third area that is not met in this. But we know, because of the commentary of human rights organizations, that criminal law is applied illegally to Sahrawi civilians, and including for political type offenses around the question of self-determination or Sahrawi identity, or as that identity was being expressed at Gidem Izak. There is then the question of identity and status and things like paperwork and citizenship. And we know about those cases as Sahrawi travel back and forth, as they seek to leave the occupied territory. They need to take on identity papers and passports from Morocco. On the one hand, there must be an orderly scheme of registration, licensing, and travel documents by an occupier. So that suggests the occupier's framework, or the occupier's documents and requirements, right? And we know of the celebrated cases where Sahrawi have refused to adopt or accept things, in particular passports. On the other hand, you cannot use, and this is the point I'll conclude on, an occupying power can't impose those status, registration, which also goes to citizenship and identity to participate in an act of self-determination as well. That maybe is the heart of the problem, beyond just getting in and out of the country or a driver's license or passes to move around, which of course can confer a sort of second-class citizenship, sort of maybe result in a kind of apartheid scheme themselves, right? But the core of things were our identity and a preserving of identity towards self-determination, and not using such schemes of registration, control of movement, passports to deepen or further an occupation annexation. That's where things become, where there's a bright line, where things are wrong.
Thank you. And another question from the audience. This was in regards to Spain. So, is it possible Sahrawis who were born under the Spanish era to sue Spain, particularly those who are born as Sahrawis Americans? And the second question, this comes closer to this. Just this was Dakhla city was invaded in 1979 after the withdrawal of Mauritania. What's the legal status? How is Madrid Accord not valid from the very beginning? And can the Sahrawi in the occupied territory resort to Moroccan always court system to resolve disputes and other issues? Wouldn't that be legitimization of the Moroccan presence in the Western Sahara? Is there an alternative legal system for the Sahrawis to use apart from the Moroccan legal system? And then we will have 2 or 3 more questions, and that will be in regards to the natural resources.
Okay. Let me try and move through those efficiently. Gosh, those are such great questions. Yes, I think the law is sufficiently clear, and there's a more and more a foundation or an access to using the law, that a challenge in Spain to Spain's historic responsibilities is possible. I sense this question is coming out of the May 29 decision of Spain's Supreme Court, the Tribunal Supremo, on the question of citizenship under the country's civil code for Sahrawi people. It's a quite short decision that said the civil code does not extend, does not provide for Sahrawi people to take Spanish citizenship. And there was initially some discussion, and I imagine my colleagues in Spain, people like Juan Soroetas Lecheras, are grappling with the issue. And we should also all be thinking about it. It's a decision that is correct in law, but it relies incorrectly on Spain's 1975 statute or legislation, which ended or tried to end Spain's responsibility in Sahara Occidental and Western Sahara. There's all sorts of things that can be done in a number of places to compel further action. In a way, this is what the people in the United Kingdom did. Allow me sort of this illustration. In 2014, Western Sahara Campaign UK brought a case against the United Kingdom government. And the purpose of the case was to say that the United Kingdom government could not allow the import of agricultural products under the same European Union tariff or import tax as would come from Morocco. So people who are United Kingdom citizens took their government to court and said, you are wrong to allow this. You cannot allow that treatment, that taxation, to be the treatment of agricultural products from Western Sahara to be the same. And then the case went over into the European court. And the interesting thing is the case came back into the United Kingdom courts. And the United Kingdom court said, well, there's the result out of Europe. And the result here in the United Kingdom is that the government cannot allow this. It limited or bound the United Kingdom government. It's a remarkable thing. It's really kind of the first time anywhere that a national government in a decolonization issue, but certainly when it comes to Western Sahara, was limited or bound. So there are possibilities for the same sorts of things in Spain. Yes, an historic case that says you need to move on with your decolonization responsibility. Or what I had said after the May 29 Supreme Court decision, a case to challenge the governments relying upon or using the 1975 "we're no longer involved" statute. I think it's time to take that statute through the courts, and if necessary to the European Court of Justice. I'd have to think about how that works, and to declare it illegal. Yeah, it's not being much relied upon, and the criminal courts have overcome it, sure, but it's a kind of cornerstone. And if you remove the legal excuse from being obligated, maybe you move things politically towards re-engaging that responsibility. So there's things that can be done there, and we should be creative because we have access to the courts of Spain. DACLA, the legal status. I'd like to remind people that both Mauritania and Morocco invaded Western Sahara on the same basis, or the premise, the same idea that they were recovering historically lost territory, and that Mauritania would apologize for that and admit it was wrong in 1979 in its agreement, its peace treaty with the Frente Polisario. I'd like to remind people of that. Mauritania would do the right thing in the end, and not in our Western and global North countries, not many people sort of know about that. And it's a good way to sort of challenge the legitimacy of Morocco's thing. But the answer to the question is, DACLA changed hands from one occupying power to another, neither presence of which is or was legal at the time. It was just a change. Does the Sahrawi entity or government have a better claim? No, I don't think so. Morocco has no claim at all. And so sovereignty to be worked through in a self-determination process, again, that's agreed upon, is what restores or allows the Sahrawi people, the process of getting to self-determination, I should say, is what allows the Sahrawi people ultimately to decide the sovereignty of the city of Dakhla. Do we wish to integrate with Spain? Do we wish to become independent, or do we wish to join some other country, is the question that would be asked. And so that, because neither Mauritania or Morocco had rights to Western Sahara, there really is no distinction when it comes to Dakhla as such. The next question was the Madrid Accords not being valid from the outset. It sounds like somebody's read something, what I had read. There are several of us in the legal community, and we are concerned with treaties. That's what the Madrid Accords was, right? Which was, again, to remind ourselves, Spain said in November 1975, as it was losing the Sahara and changing its domestic internal political civil society order at the same time. That's a significant factor as to what's going on here. Just as Portugal would lose its colonies and then return to them, Spain was undergoing this profound transformation to a democracy that was overtaking the apparently unimportant question of Sahara Occidental, of Western Sahara. So it agrees, as we know in the November 14, 1975 Madrid Accords, signed in Madrid, it agrees to a number of things. But the substance of things was that Mauritania and Morocco would administer the territory, but with all three parties still responsible for self-determination of the Sahrawi people. It was a lie, it was a fiction, but it still exists. But answering the question, the problem of international law that the scholars agree on is that Spain could not give up or delegate or transfer that responsibility. The responsibility was too great. It couldn't be shared or diminished. And And therefore, an agreement to do that doesn't exist. It's void. It's illegal. We also know in more recent years that the agreement came with some side agreements around fisheries. Spain would continue with its fisheries, and around the phosphate mines, Spain would continue to have a part ownership until as late as 2002 in the phosphate rock industry. Those agreements were only revealed in about 2009, as I recall. And the nature of those agreements also erode or remove the legitimacy of the Madrid Accords. And so a number of scholars, as well as the UN's Legal Council in 2002, have said, you know, you just can't be doing this. A colonizing country continues to have an obligation. There's a fascinating piece here you can compare to Hong Kong at the moment. The people of Hong Kong, who were a colony until 1999, a colony, part of that territory of that colony had been leased from China, part of the mainland part, the new territories, but they were a colony. Countries can't walk away from their colonies. The United Kingdom tried to do the right thing, but what the United Kingdom never did, or politically could do, was allow the people of Hong Kong some exercise or moving to self-determination. That's the gold standard. That's what the law requires, right? And it was never delivered. And instead, there was an agreement between the United Kingdom and China over the status of Hong Kong, which is now eroding, I think we can say. There's the lesson for us. There's a lesson of why to hold to the right of self-determination, I suppose. Because in law, Hong Kong's not much different, really. The international community doesn't want to call it that because it's too inconvenient for all of us. The next question. Could there be an alternative legal system in Western Sahara over that of Morocco? There probably is, actually. I've been considering writing about, and this is an odd thing, because I'm from a global north country. I'm not a Sahrawi. I sometimes think I'm a Sahrawi. Sometimes I have those dreams, you know. Well, there is an alternative legal system that applies, and it's the Sahrawi, it's the SADR legal system. If you accept that the Sahrawi state exists, then there's a government, and that government has jurisdiction throughout Western Sahara. And so the Sahrawi criminal code, the Sahrawi penal code, applies throughout the territory of Western Sahara. And I would have no problem arguing the application of Sahrawi criminal law to a criminal wrong in the occupied territory. It's just a question of finding the perpetrator, and obviously an appropriate and fair process of bringing that perpetrator to justice. I don't. So in a way, we should be thinking about that. And this is the odd thing of Western Sahara. Do we have a state, a democratic state that is existing and governing, or does a colonized people need to move to self-determination? And we sort of have both in a way. No one in the international community suggests that the Sahrawi legal system does not apply in the camps, which is an interesting thing because the camps are in Algeria, or that criminal and other legal scheme, the veterinary regulations for the hygiene of animals, does not apply in the liberated zone. There are courts in the camps and the liberated zone. So in a way, that scheme exists, and in law, it's the preferred or more acceptable scheme. I sort of like that, but how do you enforce? Who acts? Who is the police officer? What is the government? And so for the moment, the reach of Sahrawi jurisdiction of a legal system stops at the berm, or just short of the berm, right? Yeah. When I'll tell you this story, when the United Nations started administering East Timor in late 1999, they went into administration. They were the government, and they would be the government for the next 2.5 years. The UN administration, which was heavily joined by Timorese people, and it worked. It was a success. It was a little bit less than democratic, but we had a transition to deal with here. They realized, the UN authorities and Timorese authorities realized that the occupier's legal system, its criminal law system, was not really all that good. They realized they had problems applying it, not least the problem of applying the occupier, the oppressor's criminal laws, right? So they had this sort of immediate problem, and the way they got around that was they said, we must have a criminal law system. We must have a system of laws to deal with disputes and people's behavior. So for the moment, it will be Indonesia's, except where those laws are incompatible with international human rights standards, which is an interesting thing. When I talk to Sahrawi officials, I remind them, let's make sure the Sahrawi legal system is ready to be deployed. We're more advanced than they were in Timor. We've had the benefit of our own territory and our own highly sophisticated government and civil society that has been cohesive. So let's be ready that legal system simply occupies that space as it already exists. And it's a project that would need work. We have all kinds of things to think about in getting into the liberated zone. It's a wonderful prospect to think that could happen. Yeah, so and you had some more questions.
Yeah, great, thank you. I have 2 more questions, and it looks like there is another immigration-related question that popped up. So this second question, second to last question will be an interpretation of the international law in regard to the natural resources. And can you prove a reading or a legal interpretation of the latest International Court of Justice ruling on Western Sahara and its natural resources? And the immigration related to what's Canada's stand on the question of Western Sahara? And the other one is, are we stateless? When you are, for example, in a foreign nation, can you prove that you are a stateless nation, and can you, for example, apply for papers there?
Yeah.
Take Canada as an example.
Good question. Those last 2 are great, and I'll come to them in a second. I mean, we need another session on natural resources. And again, let me make this observation. It is unfortunately or sadly not human rights, including the right to self-determination, where the world meets Western Sahara. Those are the areas to explore, to advocate, to create court cases, to compel people and governments to act. Instead, the world meets or comes to Western Sahara through its resources, its prized resources that, if we think about them, and a Sahrawi diplomat wrote a paper about what those resources mean to an independent Western Sahara. Kamal Fidel in Australia 4 or 5 years ago thought through about how those resources create an economy for an independent Western Sahara. There's enough of a mix of them that it's a better economy. It's not a single resource economy like oil or some other export commodity. It's Africa's richest fishery. It's the world's best phosphate rock. And it's a number of other things that we don't fully understand, like hard rock minerals. So the fight towards self-determination has been in part through the question of resources. The people in the United Kingdom understood this. They couldn't bring a case around human rights, but they could bring a case around tomatoes, which is such an odd thing. International law is quite clear on the point. And again, there's just 2 sources to be categorical. It's now in our thinking at this point in the afternoon, almost sort of routine. there is the law of self-determination, which says that you need Sahrawi consent to extracting and exporting natural resources, and you need a benefit to them. You need both. And this was the work of Western Sahara Resource Watch in the UN Human Rights Council's review of Morocco 4 years ago, in that the Resource Watch people in Brussels advocated for this view that when it comes to consent of the Sahrawi people, that consent must be given in advance and must be an informed consent. That there has to be a high degree of agreement, of understood agreement, by the people who are sovereigns, who own the resource. And those obligations are clear. Those duties are quite clear. Brussels, in negotiating continuing treaties for fisheries and other matters, would seek to go around that. Well, we sort of have the consent of the Sahrawi people, and that's the current case by the Polisario Front in the European Court of Justice, is to say, no. Never mind the benefit flowing back, the wealth of that. The question of consent is problematic. There is, as I argue, also the other stream of what's now kind of familiar law to us, which is the law of occupation, which is more limiting, it's more stringent. It says you really can't, an occupying power really cannot be extracting and exporting resources at all, except to sustain, to maintain, to provide for the local population of people. You cannot invade a country and strip it of its resources. This was the great lesson of the Second World War, in particular in Europe. There's absolute criminal cases on that, and it's found its way into the great treaties of our time, the Geneva Conventions and the International Criminal Court Treaty. And this is an area of law that I try to remind people of, that there is this more binding, more obligatory criminal law around resources. And so a decade ago, who would have said that we would understand the law and organize ourselves to try to apply the law to defend those resources and to defend the taking of the resources, partly because it takes away legitimacy of the occupation, and partly just to preserve those resources until independence is achieved. And so there's lots to be thought and read about, but it is where the world connects. It's where the world plugs into Western Sahara. So that's why there have been developments there. They should be in human rights. They should be in criminal law. But the world doesn't come into contact with the territory in quite that way. On immigration status and other things, what's Canada's stand on Western Sahara? Like lots of other global north countries, it's not very good. It's accommodationist. We have other interests at play, and we get a free pass. We get to dodge the question and therefore not have it create diplomatic problems by simply reminding people, as New Zealand does. New Zealand, of course, is, I think, currently the largest importer of phosphate rock from occupied Western Sahara. I think I'd have to check on that. As the government of New Zealand does, we need to say, well, look, and we do say, look, there's a United Nations process for this. We are confident the United Nations organization will get through this. We support that process. And that allows us to step back and remain inactive. And then we don't create a political problem for ourselves. In the case of New Zealand relies on, it's addicted to Sahrawi phosphate. In the case of Canada, we have more important interests with Morocco than we do with or to the Sahrawi people. In Canada, we are supposed to be pursuing a free trade agreement with Morocco, but it's stalled because of the question of Western Sahara. And I think that free trade agreement is hung up. It's limited because of what's been going on in the law, particularly the European Court of Justice as such. On the question of status of persons and immigration and statelessness, certainly Sahrawi people who find themselves in global north countries or Western countries, European countries, and Canada, who claim a refugee status are going to have that fairly seriously considered in the classic sense of being refugees, whatever the Sahrawi people's citizenship as such. I can be a citizen of Canada and come to Western Sahara, and if I establish that I am being persecuted back in Canada, international law says my claim for refugee status should be allowed. I should be permitted to stay if under certain conditions in Western Sahara, sort of reversing things, right? And that doesn't turn on my status as a citizen, but rather what I am at risk of. But there is the interesting question of the status of Sahrawi people. Are they citizens of a state? If you go to Ethiopia, you're probably traveling on an SADR passport. I mean, I've seen them. My colleagues carry them. I've gotten on flights in Paris, France, coming to Algeria, where Sahrawi people are using Sahrawi passports. So that's citizenship. But that doesn't work everywhere. So there would be a parallel status of being refugees in Algeria, in which Algerian travel and other documents must be, and in general are provided. And then there's the status of people under occupation, which is very unsatisfactory. That status is not supposed to be erased or identity documents overtaken as such. But we are into this wonderful duality, a duality that can be exploited and explained away of. Are the Sahrawi people a people of a colonizing Spain? That's the citizenship case on May 29 in the Spanish Supreme Court. Or are they citizens of their own state? Or are they displaced refugees? For some people, this is a hardship. For other Sahrawi, there are advantages among the three. A Sahrawi who wishes to immigrate to Canada might be advised to claim refugee status, might be, or not. So there have been some advantages. The advantage of traveling in Africa under an SADR passport is one of them. It's a very, very unique case, yours, Western Saharas. We shouldn't call it that. There are human lives here. And that's the more important thing.
Sure. Thank you. And before we conclude, there is one more question, and that is, what is the possible extension, next step to escalate tension with the UN? Apply to the UN membership as a foreign or a sovereign nation like Palestine did? And then after that, I'd like to remind everyone that we have a survey for the feedback for this webinar. Please take the time to fill out this webinar and let us know if you have any questions for us or for Dr. Jeffrey. Any further questions, please remember to post it on the chat. But that's the last and final question that we have. And I'd like to remind everyone that we have a recording. There are sometimes some difficulties with the recording when it passes a length. So let's hope that the fact that we passed the hour that was designated for the survey does not impact the recording. And once we have the recording ready, we will send it to everyone. We'll share it with you all. Thank you. And also there was another question before, not a question, but more of a recommendation. Some suggested that they would love to have organize another session in regards to natural resources, as that's a very important topic and we can prepare for it instead of asking one or two questions. If that's absolutely possible, but we'll follow up with that. Thank you.
Okay. Yeah, I welcome that for a bunch of reasons. I think because there's so much promise in it. Such good work has been done that needs all of us to understand it better. Right, well, let me deal with this last question. What can be done in the United Nations setting? What can move matters along in the United Nations? That's a diplomatic question. You know, as we say here in North America, as the English phrase has it, it's above my pay grade. Good patient diplomacy, building alliances, the hard, painful, and frustrating work of restating the fundamentals. I also think that joining with, that creating more of a voice, more of a critical presence with solidarity, people and organizations is a good thing. My view as a kind of citizen of North America is that certainly I have left that lacking. I'm in contact with only a handful of very committed activists in Canada. They're wonderful people. They're essentially out west. Why is there not more of a nucleus and more of a discussion, of a coming together for people in civil society, you, organizations, and others, to direct that voice into the United Nations? We're coming up to October, to the 4th committee meetings. Why is there not a planning for attending those? Well, we live in a different time now with the COVID-19 pandemic, but of letter writing and engaging our governments. This is the hard work of solidarity, of understanding, of building alliances. Are there things in the United Nations that could be done? The Sahrawi authorities have always stayed away from moving more formally into the UN organization to become an observer entity or an observer state in the General Assembly, for example, that they felt that they would be reversed diplomatically and perhaps lose ground. And I understand that concern, but I think there is, again, we began with last week's development. Namibia and Timor-Leste calling out or reminding Spain of its obligations to Western Sahara in the UN Human Rights Council. There are some alliances around countries that with such a great man, Sahrawi diplomat in New York, Sidi Omar, that can be stitched together and built. But I think it's beyond that. It's organizing civil society. It's paying attention to the cases in Europe. It's thinking about the possibilities in Spain. And that's hard and it's slow and it doesn't seem to bear results. But that's how these things shift in and around UN circles. It's how apartheid in South Africa would come to an end. That the regime in Pretoria realized by about 1989, 1990 that the game was up. The new regime in Jakarta in 1998 realized East Timor was too much of a problem. The game was up. And at some point, the dam will burst. There will be an opportunity, there will be a moment in history in which just preserving the foundation, just this maintenance work that did not seem to lead to anything is now the basis for things to happen. I just, you know, I'm a student of history. I'm no more educated than anyone else is, but I really believe that.
Thank you, Dr. Jeffrey Smith, and thank you everyone who managed to attend this this webinar. We hope everyone have a wonderful rest of their days. Please don't hesitate to reach out should you have any further questions. And from the Sahrawi Association in the United States, I'd like to thank you all and have a wonderful rest of your day.
Thank you, Jeffrey. Thank you, Mike.
Thank you.
Thank you, Malay. I really appreciate your moderation. Those are great questions. Take care, everyone.
Thank you.